Welcome, everybody. I am attorney Justin Randall with Hooper Law Office, and today our topic for our webinar is on probate and sort of the basics of probate. We're calling it Probate 101. So I will walk you through just generally what that means, what that process looks like for you, and when you might actually want to use this process for your estate. So a couple quick items before I go into all the information today. If you have questions as we're going along, please feel free to submit it to the question and answer box if you're watching this on Zoom. That way, I will see your questions come up if you have anything specific that I haven't been able to answer for you just through what I'm talking through, or if it just doesn't quite hit on what you're looking at. Otherwise, you can always follow up with us through learn more at hooperlawoffice.com, at hooperlawoffice.com, excuse me, more directly. You will receive a couple things from us after this webinar through the email you use to sign up. One of the most important things is actually the feedback form that we send out. So that does a couple of things for you. One, gives you a place to give feedback. If there's topics you want to hear about or just any general feedback that you have, it's always welcome. But you can also use that form to let us know to reach out to you to schedule an initial consultation with an attorney in our office. Those initial consultations that we set up, they are complimentary. So we don't charge anybody to come in and talk to us for like that initial meeting. We want to be able to sit down and talk to you and get a general sense of what it is we might recommend, what your situation is. And that way we can give you a good recommendation before we, charge anybody any money. So those initial consultations are set up for about 2 hours. That gives us plenty of time to go through the information, on your particular situation. We do ask for some information to be brought in that can be helpful in deciding what is best for somebody that we're meeting with. Generally, like information on your loved ones, the people you want to include in planning, and then also just some general information too on like what types of assets you own, and that gives us a way that we can really design the plan for you. What is probate? Getting started on that topic. So that's probably one of the more common questions I get is, what even is probate? We hear this term a lot. What does that actually mean? So probate is essentially the legal process that somebody's estate would follow after they pass away, assuming they have no will at all, and they have no like beneficiary designations on their assets, no co-owned assets. Just, I own all my accounts and I have no beneficiaries listed on it. So if I don't have a will, the state of Wisconsin has essentially written a will for everybody saying, here's where things go if somebody passes away and they have not done prior planning. It's just sort of the default of where most people might want their estate to go. So probate is that court legal process where somebody in that situation might have their estate administered. But probate is also where somebody who has a will actually administer their estate as well. Again, assuming they don't have everything co-owned with another person or don't have beneficiary designations on their financial accounts. So probate is both the process you'd use if you have no planning at all, potentially, but it's also the process you'd want to use if you have a will. So wills specifically are a set of instructions to the probate court of how you want your estate handled, who you want in charge, how you want things divided, if there's any sort of special provisions for or like planning tools you're using for certain beneficiaries. That's where you lay all of that out. So an important thing to remember, though, is that wills do not control assets that do not go through probate. That's probably one of the most common problems we see when somebody has will-based planning, is they will have their will. It might have very good planning in it. It might be very clear on what that person wanted, but then they have assets that are payable on death or transfer on death directly to different people. Maybe the same people that are listed in the will, maybe not. That's one of the concerns when you're doing that type of planning, is making sure those things match. But it is very important, if you have a will and you expect it to be used, that you work with somebody who can help you properly coordinate your assets. It doesn't just automatically control things. So as a general sense, probate is the process that somebody without any estate planning might follow, but also somebody who has a will would follow as well. And as I mentioned, it's essentially a court process, not necessarily meaning that you're actually in front of a judge every time as that executor of the estate or personal representative, but you are filing things with the court. So what does that process actually look like after someone passes away? Well, initially, if you do have a will and you pass away, um, somebody might be named in that will, or should be named in that will anyway, as what's called a personal representative. That is the same thing as an executor. It's just the term that we use here in Wisconsin for executor is personal representative. So that person who's named in that role or nominated in that role, they or one of the beneficiaries, I guess whoever finds a copy of the will, should admit that will to probate. So initially, that person who's named in that personal representative role, they don't have any authority to act right away. So what can happen is any sort of financial accounts, checking, savings, things like that, that the person had just in their name while they were alive. Once they've passed away, those are temporarily frozen, so bills can't be paid right away. Access to them is locked down. Powers of attorney end at death, so they don't have access to those accounts either. So that can initially seem scary, but walking through the process in full, you'll understand why that's actually not as scary as it initially sounds. So once that will is admitted to probate, the court requires notice be given to all of the interested parties in the estate. So those are the people who would inherit if no will existed at all, but would also inherit under the will. So essentially the beneficiaries, potentially your heirs at law, which is essentially your, if you have kids, it's your kids. If you're married, it might be your spouse, right? It's who would inherit had you had no will at all. So that notice potentially means that it also has to be given to people who you've disinherited as well. So if I'm single and I just have, all of my kids are surviving me, well, I would have to give notice to all of them, even if I had decided, or my state would have to give notice to all of them, even if I had personally decided I'm disinheriting one of them. So that can create some potential concerns for people, but that's who has to be given notice on who was nominated in the will as that personal representative. So that process of actually appointing that person can vary in how long it takes. Assuming you get everybody to sign off on that appointment relatively quickly, it can, be a couple weeks maybe that it takes for that person to finally get the approval from the court. What they will grant that person is called a domiciliary letters, basically the proof that they are acting and can serve on behalf of the estate. But it can also take a month or sometimes longer for that person to be appointed. And that's assuming not everybody signs off on that appointment or they object to that appointment in some way. There can be situations in which that process just takes longer because of family conflict or not everybody agreeing on who's being appointed. Generally speaking, that person is not going to be not allowed to serve. It's not like the court will say you can't serve because one person objected. They have to have a very good reason for it. It's not just because they don't like the person that somebody can't serve. Generally, it has to be that they're somehow, potentially committing fraud or have horrible financial, management skills. I mean, there could be some pretty significant circumstances maybe in which somebody wouldn't be allowed to serve. But I wouldn't worry about it just because maybe one of your family members is going to object to who you appointed. The court will give them the opportunity to come forward and file that claim, but it very rarely goes anywhere because there's not really a good reason a lot of times that people are objecting. They're just upset. Once that personal representative is appointed, then what you have to do is you have to have an inventory for the estate. That's essentially all the things that are part of that probate process. So if it's a bank account, you have to put the value of that down. If it's the value of the home, what have you, whatever's a part of that estate, that inventory needs to be filed. That inventory needs to be made available to all of the potential beneficiaries so that they can see it as well. And then there's also a creditor time frame that they have to come forward. So I mentioned earlier that there is not as much of a concern around not being able to pay bills right away as a lot of people think when there's a a personal representative who's waiting to be approved. The reason for that is the court requires notice to be given to any unknown creditors, which is essentially just do that through public, newspaper publications, online publications saying, John Smith passed away. If you are a creditor of his estate, you have this time frame to come forward and file a claim. The court also requires that you give direct notice to any known creditors. So you can't just get away with that public notice if, for example, the hospital's already sent you a bill saying this is what is owed, for example, or if there's like known credit card bills, things like that. The time frame that once that notice has been given that those creditors have to come forward is roughly 90 days. So that means if they do come forward in time, they've gotten that notice, they are able to file a claim against the estate. And then once that time frame has passed, if there's funds in the estate to pay those claims, the personal representative has to pay those out of the funds of the estate. They're not personally responsible for those debts. However, in a lot of cases, when a creditor misses that deadline, now this can vary depending on what the court wants to allow, but in general, if a creditor misses that deadline, their claims may not be valid at that point. They may not be able to recover against the value of the estate. Personally, I've seen situations in which somebody was late on their creditor filing, believe it was a hospital in this case, late by about 6 months. And they were asking if they could submit that claim. And in that case, because they were so far beyond that time frame that they had to come forward, the estate actually didn't have to pay that claim. So in some cases, even though bills can't be paid right away, and that sounds scary, in some cases, it can actually, unexpectedly lead to actually having more money left over than you would have expected because the creditor themselves didn't do what they were supposed to. If you are the personal representative or a family member and you're getting calls from a creditor that is, saying you have to pay us or we're going to, do X, Y, and Z, they are not allowed to do that. There is a process for them to follow. The only exception to that is if you co-signed on a loan or are also responsible for it personally. But you don't have to worry about that just because you're the personal representative waiting to be appointed or just because you're related to the person. So after those bills are paid and after the inventory is filed and all of that, then that's when you can start the process of actually dividing out the funds to the people that are listed in the will. And how you divide it, of course, depends on how the will sets that up. It is generally one of the last steps of that process other than the final accounting for everybody and the final tax return for the estate and all of that. So I just went through a lot of different things potentially that need to be done in probate that are required by the court, and it's a very regulated process. The downside of that process, of course, and it being so regulated, you may have already noticed some of these waiting timeframes that people have, potentially a month to be appointed as a personal representative, potentially, about 3 months for creditors to all have a chance to come forward. I mean, right then and there, that's about 4 months. Well, overall, this process generally takes, and this is assuming things are going smoothly and people aren't contesting things, but generally speaking, the entire probate process here in Wisconsin, an average time frame is 1 year to 1.5 years from start to finish. Now, that doesn't mean that you don't have access as personal representative that whole time. It doesn't mean that there can't be potentially earlier distributions to beneficiaries, but from the moment that will is filed to the closing of the estate, it can take about 1 year to 1.5 years. And obviously, if people are objecting to things, that entire time frame gets lengthened. Especially if they're objecting to every little thing, you're going to have hearing after hearing on it. So probate can take one of two different forms. I sort of alluded to this earlier, but didn't clarify. Probate can either be formal or informal probate. So formal probate is probably what most people think of when they're thinking about being in front of a court or having a court handle things. Is formal probate is you're going in, you're doing hearings, you're not just submitting things electronically all the time to the court, you're actually going into court and dealing with the estate. Formal probate is actually probably by far and away the least common type of probate that somebody might actually be experiencing. Most probates that we deal with, for example, are actually the informal probate process. And what that essentially means is you're still having the register and probate, the judge, agree to what you're filing. It's still being like overseen by the court, but you are not generally going in front of a court for hearings, for arguments or things like that. It's sometimes referred to, you'll hear people say kitchen table probate because you're filling out all the forms at your kitchen table and submitting it. You're not actually in front of a judge. So it can be, that is by far and away the more common process that I would say we run into almost universally. But just generally speaking, the court wouldn't be able to function if every probate was formal. So probate can be a lengthy process. It can be a potentially expensive process too. There is no set fee that you'll see for probate, but generally speaking, it's not uncommon to see the entire cost of a probate range anywhere from about 3-ish% to 5% of the value of the estate. Some of that's made up of just the court's filing fees. Some of it's made up of what the personal representative, the executor of the estate, is actually allowed to take as their personal fee for serving. And that's generally around 2 to 3%, just almost universally in that case. They almost never deny it. And then obviously attorney's fees can be a factor as part of that too. And what their fees end up being depends on, I guess, how they charge, what the complexity of the situation is. But that percentage sounds maybe not like a huge percent, but it can be a pretty expensive cost when you're talking about a more sizable estate going through probate. A $1 million estate, including the value of the home, life insurance, bank accounts, investment accounts, I guess, however you want to make up that $1 million. It's not that hard to get to that point these days, especially with having real estate as part of the estate. So that fee could be a $30,000 to $50,000 fee on a pretty average probate with that size estate. So it can be expensive. There can be a lot of reasons that people want to avoid it. The time and cost being among those reasons. Some people want to avoid probate because it can be more public than avoiding that process. So I've talked about how notice has to be given to certain individuals, and in a lot of cases, the people who are being disinherited under the will also have to be given that notice as well. So if you want to keep that more private from those people, or you think that those people are going to cause problems because of their disinheritance, sometimes giving them more information and access to information through a public process like that can be undesirable. Although that's more of a personal decision at that point, how private of a person you are, whether that's the primary reason you'd be avoiding it. So when do you actually want to use this process? When is it beneficial to use the probate process? Well, just from a general sense, if your will is your primary tool that you're using for estate planning, you want some level of probate because you want there to be guarantees that your wishes are followed, that expenses are paid. So when we're talking about how a will can help guarantee that, well, the personal representative, if the funds are part of the estate, they have access to them, they have to pay those expenses, and then they have to follow the terms in the will. Those terms can just be how they're dividing things up percentage-wise or dollar amount-wise, but it can also include things like, did you set up trust funds for minor children? Did you set up a supplemental needs trust for a loved one with a disability who has means tested benefits? And that's very important that they inherit that way, as opposed to just receive the funds themselves. If you have very careful, specific planning in your will, you want to use that process, at least for a bulk of the funds. So generally speaking, probate is great to actually follow the will because that's the only place that has any bearing on what happens. Bill paying, I mentioned sort of in passing, but that is probably one of the biggest problems we see when people have wills and then just beneficiary designate everything out to the individuals right away. And if you have a payable on death or transfer on death designation, that will circumvent the will. It'll skip the probate process entirely and just go directly to where those designations point them. So the reason people will do this sometimes is they think they're getting around the bill paying issues created by the personal representative not being able to act right away. So in some cases, you will see that they named the person they've also named under the will as personal representative. They've named them as the beneficiary on certain accounts. Well, the problem with that is, although it gives them immediate access and they can start paying bills right away, they also don't have to do that because now you've made them the beneficiary. You've made them the owner of those funds. And as the owner of those funds, they are not obligated to do any of those things. That can also create problems because even if they want to follow your wishes and divide up the assets the way you would have wanted, or pay bills on your behalf, they can run into issues if they themselves have any sort of means-tested benefits like Medicaid. You're not allowed to give money away in that circumstance without kicking yourself off of benefits. So in that circumstance, that's essentially what you're asking them to do, is gift money to the beneficiaries rather than just have your will direct it. Gift money on your estate's behalf by paying off creditors they have no reason to be paying. They have a reason to potentially be paying their own, right? So even if the person wants to follow your wishes, giving them the money directly is still not as safe as just having them have access to it as the personal representative. When that happens, if they are in charge of the estate, their own personal liabilities do not matter for the estate. Them being a personal representative, being on Medicaid is not making your funds available for that concern. But it also means that they have to pay your creditors. They are, required by the court to do that. And then they have to follow the terms of the will in terms of if there's funds left over, right? So probate is a way to guarantee the results happen the way you want. I mean, the only thing that you really don't have a lot of control over is necessarily how much money you have and if it's going to be enough to pay off creditors. But that's at least if there isn't enough money to pay off creditors, then nobody is personally responsible for it at that point. That process was properly followed. So the other side of that can be when somebody says, all right, my will says everything goes equally to my 4 kids. And one of those kids is the personal representative. So sometimes people will give all of their accounts out via beneficiary designation equally to the kids or according to their will. The problem with that is, yeah, initially they did get everything they were supposed to, right? They did get that proportionate amount. The problem with that, though, is that now who pays the bills? Because again, nobody is responsible for paying those bills. And even if one of those kids is the personal representative and decides to use some of their funds to pay those bills, well, there's no guarantee that the others are going to equally reimburse them. And they may end up with actually less than you would have intended in terms of the overall percentage of what's left. If I use all of my 25% out of 4 kids to pay mom and dad's bills, and they decide they don't want to pay me back, if that's not going through that probate process, I may be out of luck. I may have done the right thing and gotten burned for it. So if you actually don't want that to happen, then again, having things in the probate process actually means that bills have to be paid first before everybody gets their share. So you are all sharing in those expenses equally. So that's a really important reason to, at least if you have a will, follow that will. But when you're actually looking at, okay, well, why would I use a will over something like a trust, for example? Because trusts can do a lot of that planning too, while also avoiding probate. So why you would use probate as part of your estate planning process after you pass is if you have minor children, for example, and you need to name guardians for them after you would pass. Guardians have to be named in your will in order for the court to approve them, right? Just like they want to make sure that that personal representative is fit to serve, they also want to make sure that you're not appointing somebody who's completely unfit to be a guardian, right? So if you have minor children that need guardians, or even adult children who have potentially like disabilities that you're their guardian for that purpose, that can also be a reason to do that as well. But a lot of times that's already sort of predetermined by the guardianship hearing too, that you may have had as a guardian for an adult child. But that is where you should be naming guardians for after you pass away, if you have those types of minor children or people you need to name as guardians for maybe an adult under your care. The other really common reason, especially these days, becoming more and more common, that you might need to use the probate process is, despite how much money you maybe have, if you have a deficit estate, which essentially means you have more debt, more liabilities than you have in terms of your assets. Well, probate is the perfect tool to deal with that. A lot of people will be given incorrect advice by a variety of sources, sometimes even maybe attorneys that don't deal with probate that much, where they'll say, oh, you only have to go through probate if you have more than $50,000 for the estate. That threshold is correct as a kind of general rule. If you have less than $50,000 in total assets, the courts have deemed that it's not really necessary to go through that standard probate process. However, regardless of how much money you have, if you have substantial debt or lawsuit liabilities or whatever it might be that needs to be settled by your estate, you still want to go through probate. It's unfortunately expensive when there's not a lot of money to go around, but it is better that there be somebody to deal with the liabilities that were created while that person was alive, whether that's debt or lawsuit liabilities, versus just leaving it open-ended and hopefully not, but could be a mess for the surviving spouse, maybe the kids to deal with, and it might be required anyway to open that probate process if somebody tries to sue the estate at that point, right? So probate can be a way to deal with liabilities even if there's not a lot of money to go around, and that's generally the process you'd want to use at that point, because then you have a court overseeing all of this and saying, all right, this is the case, these are the liabilities, and if there's not enough money to go around, then so be it, right? The last really important reason to use a will and to use the probate process is one, if you just generally have specific planning in your will that you need followed, and I don't just mean the percentages. I mean, if you've set up a special needs trust or a supplemental needs trust for somebody with a disability, if you have a trust for kids and you want that money managed for them longer than to the point of being age 18, maybe you want it managed past 25. It just depends on what you decide. But if you have that type of planning in your will, then you want to use probate. Probate then creates that trust. Your will creates it too, but probate will approve it and say, okay, that trust is now in existence. You can, start using that for that person, funding it with the assets, making sure that it actually gets created to begin with. To give you a more specific example of when you would really want to use probate for that process, as opposed to, again, creating that type of thing through a revocable trust or an irrevocable trust of your own, one of the ways that we can protect a surviving spouse who is on Medicaid from having to spend down all of their money that the healthy spouse was able to keep while they were in a nursing home, for example, or to prevent them from losing access to that Medicaid and having to reapply after they've spent down. One of the ways we have to do that planning is by creating a supplemental needs trust for that spouse specifically in the person's will. So that's not planning that we can do without the probate process. So when you would do that is one of the spouses goes into care, assisted living, skilled nursing, doesn't really matter in that context which level of care they're in. Oftentimes that person will be on Medicaid at some point. The spouse at home still gets to keep quite a bit of funds. They get to keep the primary residence, potentially keep their retirement accounts, IRAs that are in their name. If they have those to begin with, then they get to keep those. So that could potentially be hundreds of thousands of dollars, if not $1 million or more, that spouse at home got to keep while their spouse was on Medicaid. Well, in Wisconsin, you cannot decide as that healthy spouse that I'm going to not leave things to my spouse. I'm going to skip them and go to the kids. Because if you do that, that skipping of that spouse will count as if that spouse themselves gave it away, and then they'll lose access to Medicaid and not have a way to pay for their care. So the exception that we have under Wisconsin law is that you can set up a supplemental needs trust through your will for that surviving spouse, and then that not only doesn't kick them off of Medicaid and doesn't force them to spend back down, but it also protects those funds so that it can be used to supplement what Medicaid isn't paying for and potentially go down to the next generation if that's what you would ultimately want. So in that long sort of detour explanation there of why you would use that has to be done in a will. So for people in that context, we have to use probate to create it. It's not something we can do in another way. So that just goes to show you, though, that that's one example of why you might be using a will to create certain types of planning for your loved ones. So again, just to summarize, because I'm at the end of my time here, probate is the process you would use to administer your will, or to administer somebody's estate who did not have a will and actually had assets subject to that probate process. You would also want to use that process for making sure that bills are paid effectively if you don't have a trust, for example. Making sure that guardians are named for your minor kids, that the planning you have in your will actually happens. So it's a process that a lot of people try to avoid, maybe not fully understanding when it can actually be helpful to them too. The way I look at it is that probate is a tool, and it's a tool you would use for the right reasons, right? So I'm at the end of my time and I don't see any questions, but just to wrap up here, again, keep an eye out for that feedback form. Again, we offer complimentary initial consultation, so you can fill that out and let us know to reach out to you. It doesn't cost you anything to come in and talk to us. And then we won't be having an in-person event next week, but the following week, we're actually doing our Wills versus Trust public seminar in Green Bay. So we go into this topic and a lot of other topics in more detail. If you want to sign up for that, you can do so at estateplanninglive.com. And we have a 2 p.m. and a 6 p.m. session for that. With that, I will let everybody enjoy the rest of their day, and I hope to see you guys